AM 1310, 95.1 FM presents Legally Speaking. Here are today's hosts.
Good morning, everyone. This is Nathaniel Lee. Thank you so much for joining our show today. It's difficult keeping up with the numerous litigations that we see that are so different, things that we've never seen in American history. There are some that are so outrageous until we have to start off with something I think is the most outrageous reach of executive power maybe since slavery. But I got my superstar panel with me today, attorneys Grimes and Prime, and of course our super research analyst, attorney Banks. But we're going to start off today with something that's quite frankly angered me. Was in the news. You may have missed it yesterday, but a Milwaukee state trial court judge named Dugan was arrested yesterday on a magistrate warrant, not on a grand jury, where evidence of a crime presented to citizens. A single person ordered the arrest of another judge, which is unheard of in America. Normally, we see that in communist regimes. Then we saw the Attorney General last night get on Fox News and say things that were clearly outside the bounds of the document. I want to discuss this matter because the case, quite frankly, angered me, because it seems to me that the executive branch of government don't like all these adverse rulings and now is openly attacking judges. That's right, I said it. They're attacking judges because they don't like the outcome of these unconstitutional things. And my prediction is also this Attorney General Pam Bondi, once the controller of House and Senate change, this be grounds for a clear ethical violation for her going on the news and saying this crazy stuff that's outside the boundaries. Lawyers in litigation are not allowed to just make things up in the public for pending cases. I suspect there's going to be consequences. But in any event, good morning, everyone. Did you get a chance to read this outrageous assault by this U.S. attorney on this Judge Dugan in Milwaukee, Wisconsin?
Yes. Good morning, Nate.
Good morning.
Yes, good morning. Good morning.
Well, Vanita, you had a chance to read this, counselor? Okay, I lost her. Okay, wait a second. Did you get a chance to read the indictment? I'll start with Attorney Prime, who worked at the Justice Department. He had 30 years. Have you ever seen anything like this before?
No, I haven't. One of the things that's really important is that, we have separation of powers. We have three branches of government, and then we have a federal system and a state system. And one of the things that is really pounded in our heads at the Department of Justice while I was there before retirement is that you need to have respect for the other branches of government. There are co-equal branches. Now, we have the, executive and legislative, and judicial branches. And so in this situation, we're talking about a state court branch. So what they're always going to look at is, how are the least drastic means to kind of effectuate, what the Department of Justice is trying to accomplish. And I think, Chief Justice Roberts got it right when he basically said that if you are critical of a trial court judge's opinion, the proper mechanism is an appeal. And I think the proper mechanism here, if they believe that this judge was acting inappropriately, if you truly want to have respect for the different branches of government, were to appeal the behavior. There are judicial complaints that could be filed if you think that this is inappropriate. But it's a very, interesting and difficult step, in my view, of arresting a sitting judge who's a co-equal branch of government. And, the other thing is you have to look at the context. The context is that there have been a lot of criticism by this administration of the judicial branch. So it just sends a chilling effect on existing judges that, hey, if you don't rule in favor of the administration and see things the way we do, that you're going to be criticized and possibly arrested. So I think it is something that's unprecedented and something that we should be concerned about.
Hey, Milton, what are
Yes.
your thoughts? You ever seen anything like this in all your years?
Nate, I agree with with what the law, how the law is describing our responsibility, as Mr. Prime said, but I believe this situation is distinguishable from that description of what our responsibility is. This is conduct by a judge, not sitting on the bench, ruling on a situation. This is conduct outside of that. This is conduct that they're saying she participated in harboring and secreting and concealing and aiding in the escape of a person that had a legal warrant existed for. Whether or not this is a judge or a magistrate's warrant or some body of government warrant, it undoubtedly is a warrant that is executed by law enforcement. They came, they notified the court and the staff that they were there, and they were there for the arrest of Mr. Ruiz. The judge took on the additional task of trying to keep him from being arrested, not from the bench, but from personal behavior and conduct. It's no more different than a judge friend of mine that we had cases against each other, and then we became friends 2 years ago. He and his wife was arguing in the living room. He took out his gun from his ankle holster and boom, killed her, and went on trial about a month ago. The jury was hung 11-1 for conviction. It's going to be retried. But this was an act outside of his judicial authority. This behavior of hers, I'm afraid, will be looked at as conduct and action outside of her judicial responsibility. Just because she was in the courtroom doesn't make everything she do or does protected by the law, protected by administrative or ministerial or collective action that has been voted on and given her authority to do. I think prosecutors, Mr. Prime would agree, he was a prosecutor for a number of years. They can go out to the scene of a crime and observe an investigation, but once they participate in that investigation, it takes them out of the protection of their job, and they may not be immune for what they do or any misconduct by them or law enforcement. So I am upset by what's happening in this country, but I don't think we have to join with the administration of our country and just do what we want to do because we don't like it. So I don't know that they didn't have the authority to arrest her for her behavior. This man was captured out there on the street in front of the courthouse or down the street from the courthouse. They respected her authority when she said, don't arrest anybody in my courtroom. The supervisor judge was supposed to be writing a directive that would give the whole entire inside of the courthouse a sanctuary type of protection that you can't arrest anybody in here. I don't know if he had finished writing that directive or not, or they were working on it or not. So I don't know, guys. I think we should calm down until we get all the facts.
Yeah, I agree that we should, look at all the facts. But I think one of the things that, is really interesting to me is that just because you can do something, the question is, should you do it? When you're looking at a co-equal branch of government, I think they have to look at the fact that are there least drastic means, and would this be a chilling effect, especially given all the existing disputes the administration has with the judicial branch, mostly on the federal level, but we also have seen some state levels as well. Now, you correctly indicate they did capture this person, shortly thereafter. So, had I been advising them, I would say, well, hey, if you're concerned about the behavior, given its co-equal branch, hey, file a judicial complaint, regarding the behavior, file an ethics complaint and go from there, because it's just so dangerous in terms of democracy to arrest a sitting judge in this situation. And I get it, the issue of the example of someone shooting somebody is a little bit different, in my view, than somebody who's actually in the courthouse and it's ancillary to a judicial issue. Now, I think you are correct that, we have to, as a judge, you have to honor, warrants and things of that sort. But I just think, given the totality of circumstances, there were least drastic means. And I just don't think it really helps us in terms of democracy, in terms of respecting each of the judicial branches and their important roles, in my view.
I agree that ICE should not go in and arrest people in the courthouse. I believe that there's a sanctity or something it should be protective of individuals to go in a courtroom, and maybe even a courthouse. But in this case, that's not kind of what she did. That's not, she secreted him. She participated in his escape.
Wait a second. Let me correct everybody on something.
Sure.
Paragraph 33 of this affidavit signed by the FBI, 33, it says this: after leaving the judge's vestibule and returning to the public hallway, DEA Agent A reported that Flores-Ruiz and his attorney were in the public hallway. DEA Agent B also observed Flores-Ruiz and his attorney in the hallway near courtroom 615 and noted that Flores was looking around the hallway. So in other words, everything that you talk about, there's one big distinction, folks. Here's the deal. The judge took him to a jury room, but then he leaves the jury room into the public setting with the DEA agent that they observed with him and his attorney. So she did not escort him out of the building, what the AG said. She escorted him to a jury room, and then he leaves there with his attorney. So he's in the hallway. And so my concern is this was not a grand jury that heard this evidence. This was an affidavit, arrest warrant presented to a magistrate, and he signs an arrest warrant that has a fatal defect. If the charges that they made are accurate, then it's contradicted by the statement in paragraph 33, and that's the point we're making. So we're saying that she concealed them, but she had nothing to do with him leaving the building. That was he and his attorney, according to the affidavit. And that's what my problem is, that
one with her actions before he's seen in that area of taking him through the jury room and out the back where normally defendants who are not in custody don't go. So her behavior to them appeared to be one of keeping him away from the agents. I'm just trying to look at the facts and see what her conduct was. I'm upset with the administration for a lot of reasons, but I'm saying, looking at these facts, it looked like she participated in his escape and obstructed or impeded the department or the agency there, ICE and DEA and other federal agents, from arresting him. And she participated in the concealing and the prevention of arresting him by keeping him away from them, Nate. Now, if he ends up back in front of them and then they pursue a foot chase on him, that's that. But before then, she wasn't sitting up there on the bench ordering things and conducting court.
Yeah.
Well, she is in control of her courtroom, in my opinion, Attorney Grimes. And I do believe that, as Attorney Lee stated, that number 3 is contradictory. Number 33 in this FBI agent's affidavit. I think holistically, as Attorney Primes has stated, there are 3 branches of government. And that in this case, instead of this type of harsh, chilling effect, in my opinion, targeting, making an example of this judge to instill fear in the judiciary, there are other methods to address the situation, including an ethics complaint, or some other type of complaint filed against this judge to address this specific situation. And I think that, of course, the facts will need to be further reviewed. But from my perspective, this case will ultimately be dismissed by this judge, against this judge.
We all got opinions about it, y'all. All I'm trying to say is that a judge, and believe me, I would support her to the ninth power, but a judge has a responsibility to act and behave in a certain way as well as everybody else. And I just think she stepped outside of that in this particular case, even though it was for a cause that I support. That's all.
So what do you think the remedy will be? What do you think that this final disposition will be?
I think her behavior has to be questioned and addressed. And I think the final disposition, if you want to guess at it, Vanita, that's all we're doing. I think that she would be held accountable for her behavior outside of her bench. That's all. And I don't think she should go to jail. I think she should be censored for it, etc. But if judges take it on their own to say, because I'm a judge, I could do anything I want in this courthouse or in this courtroom, I've seen too many of them act in that fashion that was detrimental to the party, especially a defendant in a criminal case. And so I'm looking at the bigger picture than just this one incident favoring behavior that we support. But she acted outside of her legal authority in doing that. She was no different than you or I coming in there and saying, hey man, come go with me. Get out of here.
I mean, working for the federal government for 30 years, I can tell you that there are so many internal disputes, whether it be with other federal agencies that we represent. And my point is that issues like this have been going on, for some time, because the things that local authorities have been saying is that this is an underfunded mandate. You're requiring me to keep someone in state custody. They may have an immigration issue and the federal government isn't paying for that custody and care. So local jurisdictions have been screaming for some time about this. My point is that there are least drastic means. This should be, a discussion, above higher levels. It did not have to, manifest itself in the manner it did, where you have, law enforcement, that is in this full blown dispute in public eye. These are things that should be handled in high level meetings, conversations. And if you're concerned about the behavior and thinking that, hey, you were obstructing, hey, to me, given the stakes being so high that you're talking about a whole different branch of government, you want to, tread lightly and use the least drastic means, in my view. Could they do it? Yeah. Should they do it? No.
Marlon, this wasn't a situation where they were asking the local authorities to participate in any way, shape, or form. They weren't asking them to hold them in a holding cell. They were not asking them to do the arrest or anything. They simply came to get that body and take it to these terrible facilities they call holding facilities, etc. And I agree that all of that is almost inhumane, but the fact remains they weren't asking for the local authorities or the court to participate in any way in the arrest or the detention of this individual. And that's kind of the difference. That's all I'm saying anyway.
Well, here's my prediction. Unless that arrest warrant affidavit is amended, the charge will be dismissed because the charges that he's charged with is contradicted by what's in the actual affidavit.
I don't agree.
I mean, it's a red herring. If you say that she escorted him out of the building, and in your affidavit you say that he's with his lawyer leaving the building, I mean, a 5-year-old can figure out that that's a serious flaw. Maybe I'm thinking that this magistrate judge didn't look at this correctly. The magistrate judge should have denied this on the face.
Exactly.
So they're almost saying you did not hold them long enough. And, so I think that is problematic. But again, I just think that given all that's going on, there are times when we need wise men to dial the temperature down. And it's just unfortunate that we didn't have wise men and women to dial this back before a sitting judge is arrested. I think that just the optics of that are going to go all around the world that, hey, a sitting officer while they are in court it has been arrested. And I just think that, there are least drastic means that could have been used. And, these disputes happen all the time.
We see.
And for it to, manifest itself in this way, to me, I don't think it benefits any of the branches of government. It doesn't benefit the Department of Justice in terms of people having respect for what they're doing. It doesn't benefit the local judiciary. I think that there should have been a better resolution than an arrest of a sitting judge. Now,
I agree wholeheartedly, and we're very, very interested in this particular situation. There are so many other issues as well.
But we're talking about
number 27 of the affidavit
states
that there was a call to the chief judge, and that the chief judge had stated that they're working on a policy which would dictate locations within the courthouse where ICE could safely conduct enforcement actions, and that the chief judge emphasized that those actions could not take place in courtrooms or other private locations within the building. And so I agree that on its face, there are inconsistencies that should ultimately result in a finding in favor of this judge, in as much as Attorney Lee has earlier stated that the suspect, if you will, was in a public hallway with his lawyers. And so from my perspective, this case will ultimately be determined in the favor of this judge, but we'll see.
Okay, caller, you have a question or comment for us today. Go ahead.
Good morning. Good morning. How you all doing?
Fantastic, Imhotep.
Good, great, riveting discussion here. Very good, as we call in school, argument, as they say, and the claims behind the various arguments. I'm enjoying this. I will ask you this, Milton, and I've got the greatest respect for you, but I'll ask you this. I understand exactly the logic behind your point and the letter of what you're saying the judge did. But yeah, we have a president who just thumbed his nose at a 9-0 decision. We have a Justice Department, Pam Bondi, who thumbed their nose at various decisions from judges, and none of them have been brought to bear. We just had the House of Representatives pass a bill to defund federal courts and stricken the power of judges. We're getting that type of talk here in Indiana. I'm sure Nate is familiar with it. They're talking about that same kind of bill here. So kind of surprising from you that I would hear you defending this in the light of on the other side, they're thumbing their noses at judges. They're thumbing their noses at the Supreme Court Rule 9-0. And they basically told them, we ain't doing nothing you say. So last thing about judges, and I'll get off of it. We got a case in Texas of a young man who's claiming self-defense. Carmelo Anthony's his name. He's not the basketball player, but his name started with a K. And his bond at first was black and white. You know, it's just brought all these things up, like from Zimmerman and everything else, Daniel Penny and all that, those people. And a black GOP appointed judge, female, down there lowered his bond from $1 million because she looked at that he may have some claims for self-defense to $250,000. He's been let out. She followed her judicial purview, was in her purview. And she gave him $250, and he's out. He got a GoFundMe. It's not GoFundMe. They canceled that, that's a whole other subject, how they GoFundMe treats white people accused of things and then how they treated him. But he had another Go Something page that raised almost $500,000. So his bail was $250. Let him out. He's at home. This judge is now receiving death threats. This judge had to change her number, had to hire security, and everything. I just want to be clear that when you take that position about judges overstepping, you must take the same position when those very people who are put that judge in jail are thumbing their noses at the judges at the same time and want legislation to basically strip them of any power because they're blocking the president's agenda. So I just want to throw that out there. We've got a big problem here, and it's easy to say, yeah, she overstepped, but then look who's really overstepping. Look who's really overstepping. And look at the judge in Texas, what she did. Now look what she's facing, which all she did was used her judicial freedom that she had, lowered the man's bond, and then he got out, and now she's riding around with security. So I just want to throw that out there. Thank you for taking my call. Appreciate you, Nate.
I think we're arguing about two different situations. We don't like them arresting, charging the judge. We're also dealing with this judge's behavior, and those are two different factual situations. What the federal government has done, the U.S. attorney has done by filing a complaint against her, that's one thing. The other thing is her conduct. And so, but I think we're joining the two together, and that's not the way I would analyze the situation. I am concerned with judges overstepping, because my experience through the criminal courts has seen that too many times, and we want to hold them to the rigid requirement of the law and following procedure. She stepped out of that procedure, y'all, and that could be very harmful in a lot of cases, and in most cases, I think it is. Whether or not they should have taken her conduct to a grand jury and let ever how many people of her community decide whether or not this was criminal conduct, that's one thing. But they don't have to take it to a grand jury to be legal in filing an arrest warrant for her. You follow me? That's all I'm saying. I'm not supporting the government's behavior and what it's doing to our citizenry here today. I'm not afraid of you putting me in that corner. I'm just saying I don't like judges stepping out of their authority and dictating everything in the courtroom as if they're God.
Okay. Attorney Prime, one quick question. I've seen almost my career all these type cases presented to grand jury. Why is there such a quick filing of a case of this significant without following that protocol? I was just curious, is there any justification? I know when there's a flight risk, for example, there's something, but we're talking about a sitting judge, they ain't going nowhere. So why? Okay, while we're waiting on him, let's go to our next call. Caller, you have a question or comment for us. Go ahead. You need to unmute, caller. Hello? Go ahead. You have a question or comment for us. Yeah, go ahead.
Yeah, I got a comment. This is Pierre. I agree with Milton wholeheartedly, and I don't agree with anything that the Trump administration does. But hey, there's a new sheriff in town, and you know it's this would have never happened under the Biden administration. But to Milton's point, judges stepping out of their bounds. Now, I'm not an attorney, don't like being one, but over the last 30 years, I've had to act as a pro se litigant in cases of, you know, with the government and everything. And I've stood up and watched federal judges allow U.S. attorneys to change evidence right in front of me. I've stood up and watched judges because it was other government officials. Once they got a complaint filed against them, they got to go back and change evidence. I mean, you know, these judges get away with a lot of stuff, especially on the federal level. But I was reading the Washington Post, and what it says is that he told the agents to go talk to the chief judge, and while they were talking to the chief judge, he told the fellow that got arrested and his attorney to leave through her chambers. Now, so they would avoid the federal agents, and I guess once they got outside, the federal agents saw them. Yeah, that's obstruction. That's obstructing an arrest. That's
Pierre, hold on 1 second. Pierre, there's something I need to. I want you to pull that affidavit up that was filed, and that's not what happened, and that's what disturbing about this. Paragraph 33. She took him to a jury room. I've been in Milwaukee courts a long time ago, but once you leave the jury room, you come back out in the public hallway, and so he is out there with his attorney. So he leave the building with his attorney, not the judge. So the judge is not having him leave the freaking building. And so that's the problem with this.
They were both number 33.
Did the judge tell them to go a certain way?
No, they were in the same public hallway as the suspect and his attorney. So the FBI, the agent, were feet away from this guy, but they decided not to arrest him until he left the building. That's what's so stupid about this. They're blaming the judge for not arresting him. And so the point I'm making is that this affidavit, if it's true, it contradicts the reason they arrested her.
Well, then she might be home free. And this has to be worked out in the facts. But the Washington Post says something else. So, we'll just have to see what fleshes out in court. But
no, you don't have to look at the Washington Post. I'll send you a copy. I'll send you a copy of the.
Well, I'll go look it up. I believe
just look at paragraphs 29 and 33. Look at the two paragraphs and see the glaring deficiency. Now look at the first sentence of what they're charging her with. Then you go to 29 and then you go to 33 and see what happened, not what they're saying.
Who will hear the court case? Will it be heard by a federal magistrate or a state judge?
Be a federal judge, a magistrate. See, what they did here is that the magistrate, what I've seen in my practice, they sign a warrant for search warrants and things like that. I've not seen magistrate judge sign arrest warrants in case like this. The cases I've seen, they've been before presented to grand jurors, and the grand jurors indict the person, and they have hearings and things like that. I've not seen this type of arrest warrant before in my 43 years. So it's something that's out of the ordinary from my standpoint.
Federal magistrates sign the arrest warrants all the time.
But not for cases like this, what I'm saying. You've never seen, in our country, I've never seen arrest warrants where they went and picked the judge up for something like this. I've never seen that before.
I think we got to make the distinction as well, is that it's not as though, there was an administrative arrest warrant. The judge went ahead and, took this person that, was alleged to be in the country illegally, took the individual in her car and took him outside the courthouse to prevent him from being arrested. I mean, that's an entirely different situation. In this situation, it's not clear. I guess a lot of it will have to be adjudicated, but it almost kind of suggests, if you compare the two paragraphs, that they wanted the judge to hold this fella, in one room, and she's saying, "Hey, look, I'm not going to do it." He goes into the jury room and he is in the hallway, and then they arrest him. You don't want a situation like this playing out in the public courtroom. Somebody's running. Innocent people could get hurt. You don't want that situation. So again, I just go back to my overriding point is that, high level people need to be negotiating in terms of how these arrests are going to be effectuated, because you're going to have that connection between the state system where someone, has been accused of a crime or adjudicated, And you have a situation where they are in a protected class because they are not in the country legally, or they have some immigration issues going on. So what the interplay is that if you are involved in a state crime, that can impact your rights as to whether or not you're allowed to stay in the country. So there's always been this interplay, and I think it's something that needs to be worked out. It shouldn't have worked its way out the way it did, because it's not in anybody's best interest in terms of respect for the different branches of government. Someone could have gotten hurt. I just don't think this is the finest moment of DOJ, in my view.
Yeah,
I think handled differently.
I think they look at the totality of circumstances here, which is paragraph 29 and 33, and you analyze them, Nate, and you take away the dust, that maybe we'll come to exactly what happened. But did the officer put enough in his affidavit to cause this judge's arrest? Sadly enough, I think he did, and it has to be now cleared up in court as to whether or not 29 knocks out 33 or 33 knocks out 29, or in there's an error in describing the order of things. The bottom line is that I think she participated to a degree in violating the law regarding obstruction and preventing the discovery of a person and his arrest. And that is strongly indicated to me. I'm not saying that they acted properly in going to a magistrate and getting an arrest warrant as opposed to not going to the grand jury, but I don't think there is any mandatory law that says they must take this to a grand jury, Nate, and they can't get a magistrate's warrant. So that's just all. I'm just trying to be a purist and looking at what the law requires. That's all. And I
think it's safe to say that we can agree to disagree on this particular one. What do you think, gentlemen?
No, I think y'all should agree with me.
Well, I respectfully dissent, and here's why. They have the responsibility to follow the law.
Yeah.
The responsibility, the judicial branch of government is an equal branch of government. The executive branch of government, in this case, I feel very strong about, overstep its boundary. For one thing, when a person has a court hearing, and say is a criminal court, misdemeanor or otherwise, the justice system has the right and obligation to make sure that for the people of that state or that county or that city, that the justice is properly adjudicated. So what, for example, if this guy caused an accident while he's a drunk driver, and they're going to put him in a foreign country and not hold him liable? What about his asset? What about his insurance? So when you usurp the justice system, at its core, you actually obstruct the rights of other people. You know, in this case, I don't look at what the charges were or why he was in court, but the point is that if he committed a crime, there's a victim. So you also harm the right of the other parties. And that's why in America, you know, there's presumption of innocence until found guilty. Well, in Russia, we see things like this occurring, but not before this administration in America. So that's my point, is that this is such an extraordinary reaction that I think that it should not go unnoticed. I think this is an intentional point that they're trying to make to intimidate judges. Pure and simple. Okay. Oh, I'm sorry, Pierre. What were you saying?
Oh no, I'm done. I was one last point. So, did the judge do anything to facilitate this guy's escape?
No, that's the part. If you look at 33,
okay, you say no.
Yeah, look at 33. He leave the building with his freaking lawyer. This thing just irked me, because the affidavit that caused her to be arrested doesn't support the charges on the face. That
okay, we'll go with
this escape of the inmate or the assailant or the defendant, but he's in your purview in the hallway in the public purview, and that's the problem.
He left
Okay.
the courtroom through the back door, which is not permitted by most defendants and their attorneys. So he kind of she secreted him away through the back door as opposed to going out the door that everybody else go out. So was that enough to say that she obstructed and impeded his arrest? Arguably so, maybe arguably not.
Okay, it
was like
a couple more
Vanita, I'm
calls.
gonna win. If I got 12 like somebody else, I'm gonna lose.
Okay, let's go to the next call. Caller, you have a question or comment for us?
Yeah, hi, this is Renee. Thank you guys again for such an interesting conversation. I'm looking at the big picture here. I'm not a lawyer, so I can't get into the fine details of whether Section 33 or 29 negate each other or whatever. I understand the argument that sometimes judges get away with doing egregious things on the bench or whatever. However, this is not what this administration is doing. They're not trying to make an example out of judges who overstep their boundaries and their laws, because there are plenty of the judges they can go after that are doing that. And this is not that case. So to me, looking at it, what everybody is going to see is that this corrupt administration that allow their own people to get away with way worse things, including the president, and all of a sudden this judge shows somebody to a jewelry room, and then that attorney and that client decide that they're going to step out into a public hallway and, and ICE doesn't arrest them there, but waits till they're out on the street. Nobody's going to buy that this is the kind of a case that you should go ahead and arrest the judge for. That's my personal opinion. So on the face of it, it is, I don't think it's going to float. And I don't think there's going to be any judge that's going to want to uphold this arrest of this judge for something like that. Now, if she was taking bets and money under the table to hide him, if she had a car waiting outside to take him away, or if something like that, then yeah, she's toast. But that's just my personal opinion as an American citizen viewing this. It's not going to go over well for this administration. And this judge is probably not going to face any consequences. But again, thank you for the interesting conversation.
Hey, by the way, Renee, I forgot to ask you about your mayor's race in New York.
Yeah, the last time I checked, Cuomo was at 39, and there was somebody else that was in second place, and then a bunch of other people had some percentage points. The problem with the way they do the races here, why we won't get a clear picture of who's truly ahead, is because there's so many candidates in there, and so they're all eating off of somebody who could be in second place or somebody who could be in first place. I don't know if all those other candidates dropped out, would those voters actually go for Cuomo, or if they would head over to the second candidate. I would think they would head over to the second candidate, because I think Cuomo probably has all the voters that he's going to get, which he's at 39% supposedly now. That was 2 weeks ago. I don't know what the current is, but I don't see him winning. I still don't see him winning, but that's just what I know so far.
Well, Renee, let me set the scene. So this all came about because the current mayor, Eric Adams, was indicted, and he then got a special deal with the Trump administration. Initially, they dismissed the charge without prejudice based on him agreeing to do certain things for the Trump administration. Then there was an outrage, and ultimately the judge I saw a couple of weeks ago dismissed the case with prejudice, which means that for the criminal indictment for the alleged misconduct, they can't be relitigated again because they were dismissed with prejudice. Then, of course, his poll number cratered, and I saw where your mayor decided to say, the heck with the Democratic Party, I'm going to run as the independent. Is that accurate?
That's what I know so far, yes.
Okay, so if your mayor runs as independent, does that mean that the Democrat primary determined a candidate, and then in the general election, you have a Democrat running against an independent and a Republican?
I still think it's going to come down to whoever has the two that have the most on the Republican side. I don't know. You might be right about the independent. I got to check that one out.
Okay, let us know
They
next
might
week.
have, they might actually have, yes, I think you're right. I think they will have an independent and a Democrat and a Republican on the ticket.
Okay, well, thank you. Okay, next caller, you have a question coming for us. Oh, you have to unmute, caller. Go ahead. Caller? Okay, we can't hear you because you're on mute. Okay. I know, Milton, you might have some disagreement with what that lady's saying, but I think she's spot on.
Who? Renee?
Renee, yes.
I don't disagree with her, sir.
Okay.
I'm the least of the, anyway, I'm still a liberal.
Okay. Now, there was one other fascinating thing too that I don't know what you noticed this. This week, the tariff war, it was something that happened that I thought was so extraordinary. There was tariffs imposed on Canada and Mexico, and tariffs, folks, is a tax on American consumers. So when tariffs come in, you pay the tax by buying a higher price for your food and goods. Canada put a tariff on trucks going through Canada from the United States to Mexico. I didn't know this at the time, but the way that goods are received in Alaska is through this pipeline of trucks traveling through Canada. And Canada said, we're going to charge toll, which is a tariff, and which will dramatically drive up the cost. I thought that was just incredible thing that Canada did, because all of a sudden now, in 3 months, they're going to have empty shelves or inflated prices in Alaska now.
Mm-hmm.
You know, so now back to our caller. Caller, you have a question for us today, a comment. Go ahead.
Yeah, real quick now. I just want to throw this out there for a question. Now, we do know, Milton, I'll play advocate. We do know the prosecutors make up all kind of stuff. Stay with me. Prosecutor, not just judge. I know you say judges overstep. Prosecutors definitely overstep. They throw charges on, especially black folks, knowing they're just going to get one to stick. They just throw it on there. Now, let's apply that to this Justice Department and apply that to the fact that Pam Bondi fired a junior attorney from the New York district because that attorney did not lie to a judge on an immigration. I think the case we're dealing with now, talking about now, that the Supreme Court ruled on. She fired that attorney. So would you trust anything that comes out of this Justice Department? And then look at Wisconsin. This is the very state that Elon Musk tried to buy to get that Supreme Court justice seat, and they lost. I don't think it's a coincidence that they're in Wisconsin trying to do this. So just want to throw that out there. We know prosecutors do stuff too. Let's apply that same thought process to these prosecutors coming out of this Justice Department. Thank you for taking my call.
I think it's all, we got to check it and balance system, and we got to watch all of them, sir, and hold them to what we have elected our officials to set out as the law. And judges or prosecutors should not go outside of those guidelines, and they oftentimes do with no consequence. That's what I've seen.
Attorney Banks, any final comments about this issue?
I would just say that this would not be the case that I would hang my hat on or die on the vine with, for all the reasons that have been articulated. Most importantly, that there are 3 branches of government and checks and balances as well. This administration has demonstrated in less than 100 days that it has no interest in observing those constitutional boundaries. And if there was any case that I was going to argue that a judge should be held accountable, this case would not be that case. But I think we can all agree to disagree, as we have during this call today.
Well, I just think the point is that context matters, and I think the caller is right in the sense that you have to look at the overall context. You have a Supreme Court that has made a decision regarding immigration, lower federal courts, and then you have administration officials saying that, hey, they're not going to comply, and this individual, Mr. Garcia, is never going to come back. And then you have the context of a career Department of Justice attorney that is fired because he is going to be true to his oath and truthfully answer questions from the court. And he basically said, I don't have any evidence that satisfies the court's questions. And he was fired because there was an allegation from DOJ that he did not advocate as hardly, as vigorously as they had wanted. But the point is that he said he had no evidence. So context matters, and I think when you look at the totality of circumstances and look at the context, this isn't a case that I would have brought. Anytime you're dealing with a co-equal branch of government, you need to make sure you have the right case, the right circumstances. This wasn't the right case or circumstances to indict a sitting judge, in my view.
For all the audience, one of the big issues is the right to vote. And I want to clear something up before we close today. Many folks I've talked to who didn't vote in the last couple of elections because they had a misdemeanor, a felony conviction, or had been to prison. And I keep saying this, but apparently I'm not saying it enough. Once you get out of prison in Indiana, your right to vote is restored automatically. So you register and you vote. If you have a pending case in city jail, you still have a right to vote. So I don't want you to sit on the sideline in the next election because you had a prior conviction. I've had too many of you folks I've been talking to, and I'm still stunned by the fact that so many folks I've talked to don't know that they have a right to vote. And these cases we're dealing with, they all would have been resolved better if enough of you folks had voted. And that's what the problem is. So don't forget, thank you for joining us today. And please stay faith. And people that have a problem, tell them to vote. Take care, everyone. I'll see you next week.
Thanks, everyone.